Hi, I'm Shan Wu with the Undercolor of Law analysis of a big victory in court for all the thousands of probationary status federal workers. So this is a really big win. Let's break it down. And what we have here is in California, a U.S. district judge there granted a preliminary injunction broadening a temporary restraining order against the Office of Personnel Management, OPM, and its acting director, Charles Ezel, saying that this was an illegal termination of something like 26,000 federal employees. Now, this was our old friend, the temporary restraining order that the judge did first. Remember, found irreparable harm, likelihood of success on the merits, and that froze the government's efforts in place, said stop doing anything, to give more time for a fuller briefing, legal research, putting their arguments on paper, and an argument at a preliminary hearing which took place, and that would be for the preliminary injunction. So that's a little bit different than the TRO. This requires a fuller consideration. Same legal standards, actually. Judge still looks at the irreparable harm, looks at the likelihood of success on merits, but has more information before the judge, and they can even have live testimony here. And they were going to have live testimony, but as you'll learn, it turned out they didn't have it here. Those witnesses will also sometimes submit sworn affidavits and statements, so the judge has a lot more to go on by the time they reach the hearing on their preliminary injunction. Now, what the judge ordered was an immediate reinstatement of all these terminated probationary employees from Veterans Affairs, Agriculture, Interior, Energy, Defense, and the Treasury departments, and told the departments, you all have to stop terminating these probationary employees. Now, in conjunction with a case a few hours later in Maryland, this probably affects about 25, 26,000, maybe 30,000 employees that were considered in the probationary status. Now, that does not mean that they were on probation because there's some question about their job performance or their weak employees. They weren't being monitored for bad performance. A lot of the probationary status for government employees simply happens when you first begin as an employee. Different agencies have different time periods, but it's just like when you start a job, they may tell you you're on probationary status. It doesn't mean you've done something wrong and they're like monitoring you like you're a criminal defendant on probation. And part of the great injustice here, as the judge pointed out, is that most, if not all, of these employees had very good performance evaluations, and the government lied about it, saying that they were letting them go because of poor performance. This is a common theme as you hear these stories of government employees being told they're being let go, is based on bad job performance, even though they probably just had an end-of-the-year performance in which they were told performance is looking good, good ratings. Now, it's important to understand, for those of us who haven't worked within the federal government, you may know people who have, but the federal government has a really organized system of performance evaluations. It's not always a good system, and you can certainly quibble if the evaluations were fair or if there's discrimination, but there is a system of them. And if you get a bad performance, you can be put on the performance improvement plan, the dreaded PIP. You may have heard about those things. And if you're getting a problem with PIPs or you're being placed on suspension, there's a whole system of administrative review for challenging these adverse personnel decisions. All of that system's just being completely ignored by this Musk Doge crew and the heads of these agencies who are going along with it. They're allowing it to happen. And that's really questionable, really disgraceful, actually. These are the heads of agencies which, number one, meant to make sure the agency works well to support the American people. You know, Secretary of Treasury, head of Veterans Affairs. I mean, why aren't they protecting the workers that work there? They're supposed to be leading them. Instead, they're just kind of willy-nilly doing whatever Doge wants them to do, what Musk wants to blab about. And yeah, we'll just get rid of all these people, they're terrible, just so they can basically kiss up to Doge and to Trump. Now, in a critical part of the ruling, the judge ruled on this question, whether OPM, the Office of Personnel Management, even has the authority to fire people. They don't. what the judge ruled was, and people said this from the beginning, but you have a court making it absolutely clear, only the agencies have the power to fire their employees. OPM, as the Office of Personnel Management, is not some giant hiring, firing authority over the entire government. It does not work that way, and that's what the judge says. And that, of course, brings the blame right back to the heads of these agencies to blame for the illegality. And the court really lambasted them. We'll quote from some of the things the judge said in court today. Quote, "It's a sad day when our government would fire some good employees and say it was based on performance when they know good and well that's a lie." So imagine that. The federal judge is telling the U.S. government, you're lying about this. Went on to say, quote, "It was a sham in order to try to avoid statutory requirements." So the agencies now are going to have to show that they're also in compliance to the court's order. And the judge also ordered further depositions, more briefing, in particular, to find out if those administrative systems for appealing being fired are actually available, or if they've already wiped out the systems because they had a lot of firings of appeals boards. They got rid of a bunch of people in charge of those procedures. So the judge wants to know, is that even still happening right now, or did you already wipe out the normal system for protecting the employees? Now, the judge was very careful to make sure that he made the point. So the plaintiffs' attorneys, the employees' attorneys, there's actually a whole coalition of groups. We'll put up the link for you to see how many people collaborated on this team victory. But the judge wanted to make sure that it was being clear that this doesn't stop agencies from reductions in force. We often refer to them as RIFs. But this is not how you do a RIF. You don't just massively fire people for bogus reasons and lie about it and pretend, oh, it wasn't OPM telling us to do that. We just made all these decisions on our own. It's obviously bogus, but now the court has said, yeah, this is bogus. And the judge also said that he wants to make it clear, this is a quote, that the Trump administration, like any other, can engage in mass reductions of the federal workforce, but must do so by following federal statutes in the Constitution. The Office of Personnel Management directed agencies to carry out the firings, and the court concluded that they didn't follow those procedures. Here's a nice quote from that judge. He quote says, "This is not some wild and crazy judge in San Francisco said some administration cannot engage in a reduction in force." He's pointing out, yeah, you can engage in that, but you got to do it the right way. You can't just make up things and lie about it. So another interesting fact of this is that, as we mentioned before, at this kind of a hearing, there can be witnesses called. There were already sworn affidavits and statements put in, and sometimes you'll have live witnesses so that the judge can hear from them. There can be cross-examination about them. And the government, through DOJ, was going to produce the acting head of OPM, a guy named Chuck Ezel, and he was going to testify. And DOJ had said they're going to do it. But then they decided at the last minute his testimony was, quote, not necessary. Not only did they decide his live testimony wasn't necessary, but they withdrew the written sworn declaration he had submitted to assert that he never ordered the firings of these probationary employees. So the judge didn't like that either. The judge said to them, quote, "Why can't you bring your people in to be cross-examined or deposed at their convenience?" he asked, saying that the refusal to do so was a sham and that it upset the judge. The Trump administration, in an effort to help their arguments, tried to submit press releases from agencies saying that these firings were all made independently by the agencies. I mean, how ridiculous is that, right? All these agencies just simultaneously decided to review these things and made their own independent decisions. Nothing to do with OPM, absolutely. And they specifically said, we're not taking instructions from OPM. The judge also did not believe that, obviously, and ordered a senior advisor at OPM to, in the future, submit the 3 hours of depositions to go over just exactly what kind of orders had really been given in this case. So let's review for a moment what DOJ's role is, because we've been talking about OPM and now suddenly DOJ is introduced. It's because DOJ has to represent all of these cases. They represent the government in everything because they are the nation's litigator. They're the nation's law firm. No matter what kind of case it is. Criminal, civil, you always have to have DOJ involved. At this point, you kind of wonder how they have time to do anything else in terms of like criminal law enforcement, because they're litigating all of these shenanigans 24/7 at this point. So they're the litigators in the case. They represent the U.S. They take the positions for the U.S. And the judge basically said, shame on you. A few hours later, as I mentioned, a different federal judge in Maryland reached a similar conclusion encompassing even more federal workers. What was the Trump's White House response to this kind of slam dunk on their head sort of decision? The White House press secretary, Caroline Leavitt, said that the judge, of course, was wrong, right? This is her quote, and we'll put it up for you. A single judge is attempting to unconstitutionally seize the power of hiring and firing from the executive branch. And she also said the Trump administration will immediately fight back against this absurd and unconstitutional order. So this is just so typical, right? Whenever they lose, it's always suddenly unconstitutional. Now, I have to say, to be fair, pet peeve of mine, we overuse this term about unconstitutionality. We're always saying it's an unconstitutional argument so often that we use that argument that it starts to lose its meaning. I mean, why doesn't the White House say, we disagree with the judge on the law and the facts? Let us explain why we think the judge got the law wrong. Let me explain why the facts are wrong here. Instead, they just whine about the Constitution. Now, that kind of legal advocacy where you just whine about things, it's like, oh, it's unfair. It's often a sign of weak advocacy. And we have to be careful on our side, too, to make sure we bring the law and the facts into that advocacy, not just rely on saying, oh, they're a bunch of morons, it's all unconstitutional. We need to keep putting the sunlight on exactly what is wrong. It certainly is unconstitutional, but we need to explain exactly what's wrong with it. Why is it unconstitutional? And almost always, under this administration, it's because there have been structures and processes set up to make sure that we are complying with the constitutional edicts. And that's what they're blowing through, and that's what makes it all unconstitutional. So we have to keep our eyes focused on the law, on the facts. Right. But today was a good day. That's a really important win. We'll see where it goes from here. We'll keep an eye on it for you, and keep those replies and comments coming. It's really wonderful to hear from you about what you're thinking, what you think of our programs, and also what things you think we should cover too. So we will talk to you soon.